appeal in the matter of CNM Estates Limited and Carvill-Biggs and others.
Good morning, Mr Lundy.
I appear on behalf of the appellant in this matter, Mr Simpson, King's Counsel, appears on behalf of the respondents together with Miss Barter, and can I just offer my thanks to Mr Simpson for inviting me to join him on the front bench. I hope your lordships will grant me that indulgence as well.
We're very happy with that, thank you.
Thank you very much. This is an appeal against the order of Miss Dias QC of...
as she then was.
As she then was, yes. On the 14th of June, whereby she dismissed the claimant's application to re-amend its particulars of claim so it could advance a case of gross negligence and willful misconduct. Claimant's claim is a claim for damages against the respondents who are receivers arising from their receivership of a substantial commercial property site near Kingston upon Thames, just off the A3, which you may be familiar with. The reason for the application is that in June 2020 there was a trial of a preliminary issue as to the meaning and effect of certain exclusion and indemnity provisions in the security documents, and Mr Justice Foxton determined that the receivers could only be liable on the claim if the claimant could establish gross negligence or willful misconduct. The application was made on the 9th of May, and I'll deal with the procedural history in a little bit more detail in due course. It was dealt with at an adjourned second case management conference which took place on the 25th of May 2022. And the application was broken down and dealt with in two parts.
Where is the application?
The application itself, it is in the supplemental bundle. And it's at tab 21. Page 232. And it's an application which you see in fairly short form, supported by a witness statement, which you'll find at tab 22, page 236, a witness statement from Mr Samady.
So, re-amend.
Re-amend. And I'll deal with how we came to deal with it in two parts when looking at what the events of the hearing on the 25th of May. That essentially the deputy judge took the view that if I were to raise a claim in connection with gross negligence, I would need relief from sanctions, or my client would need relief from sanctions, and so it was dealt with immediately that day. And then we proceeded to have argument as to whether or not I could nonetheless have permission to re-amend to pursue a claim for willful misconduct.
So the date that you were due to file your re-amended particulars of claim was what? Under the order of Mr Justice Foxton?
No. So
under the order of
Mr Justice Bryan.
Mr
Bryan. It was an unless order agreed by consent, and I'll take you through all this in due course. The date by which a draft had to be prepared in preparation for the second case management conference was the 14th of January. And that order was in the form of an unless order. I can, if you'd like to look at that now.
Yeah.
It's at tab 12 of the same supplemental bundle while we're there.
Yeah.
Page 140 of the supplementary bundle number 1.
So the claimant shall, by a particular date and particular time, serve and see file draft pleading, failing which claim should be struck out. And you did.
Yes, we did.
You did file it.
Yes.
Yeah.
And then, whilst we're looking at this order, if one turns the page, because part of this is about the judge called the spirit and intent of the order, you'll see that the second paragraph relates to the order for a second case management conference on the first available date after the 14th of February, so that directions may be given in relation to inter alia the proposed re-amended particulars of claim and any further directions required in relation to amendment of pleadings.
So how does that affect the order, the paragraph 1?
Well, in simple terms, we say that we complied with the consent order, the unless order, we served the draft.
Yeah.
The order itself doesn't deal with an application to re-amend in terms. And it will be my submission in due course that if one is looking at what was intended by this order, it is obviously that there should be some progress being made towards the second case management conference, but that my client was not necessarily to be tied precisely to the draft which was served on the 14th of January.
What, obvious? What do you say? It's obvious?
No, I didn't say it. I don't think I said it was
yeah.
obvious. No.
What did you say?
That the intention
Yeah.
of the order, in my submission, is that a draft should be prepared.
Yeah.
The order doesn't deal with an application in terms, because in my submission what can happen, and indeed what did happen, is that a draft is produced. There can be then exchanges between the parties relating to the draft. Consent might be forthcoming. Particular points might be taken. And those might be then accommodated in the usual way and maybe a further draft. And all of those matters would then be dealt with at the case management conference.
I mean, is that realistic?
Yes.
I mean, it's not really for the other side to suggest changes to your draft, is it?
No, but in light of certain comments, and what happened, and we'll come to the history of this and again in due course, is that the 3 months expired between the service of the draft. A letter was then received which largely addressed issues of abuse of process. It was being said that it was an abusive process for my clients to amend in terms of willful misconduct. At that point, it was Mr Samady, who is the director of the claimant company.
So why did they say it was an abusive process for you to seek to amend?
They were referred to the procedural history and referred to a number of authorities which suggested that some sort of estoppel arose. It wasn't dealt. Submissions were made by the receivers at the second case management conference, but those submissions did not find favour with the deputy judge, and she made it quite clear at the outset that she didn't think the abuse of process argument was one which she was going to be persuaded by. But essentially that was what much of the focus was for the second case management conference. Everyone turned up with all the authorities to deal with abuse of process, and then, as we'll see, matters took a slightly different turn. So going back to what happened, and we can pick this up from Mr Samady's witness statement. We may as well look at it right now. As he came, make no secret of this, he instructed me on a public access basis for some urgent advice.
Where's the statement?
It's at tab 22 of the supplemental bundle, supplemental 1, page.
Paragraph.
This starts at page 238, paragraph 8. And the relevant paragraphs are 8, 9, 8-2-13.
Yes.
So what happened is the draft was served, a response was received. The response took various abuse of process arguments, but when reading the response, one did get the rather clear impression that the respondents, the receivers, viewed the draft as putting forward a case of wilful misconduct only. That was not Mr. Samady's intention. He wished to pursue both limbs, the gross negligence and wilful misconduct. And for that reason, we applied to the draft pleading what I describe in my skeleton argument as the gross negligence epithet, which is essentially that we rely upon the existing allegations of breach, and we will contend that that is gross negligence.
Whatever Mr. Samady may have intended, I think you don't suggest that the draft which was served on the 14th of January did in fact plead gross negligence. Is that right?
Well, this is where one, because I've been thinking about how one does that. Certainly one has to
I
put...
don't see we see that in any argument to the judge or indeed...
No. Well, I certainly accepted that the respondents needed to be put on notice that what was being alleged was gross negligence, even if it was the same allegations.
Well, let me ask it this way, if I may, which is, do you now submit that the draft served on the 14th of January did plead gross negligence, and if so, can you give us a paragraph reference?
There is no paragraph reference which refers to gross negligence, but in my submission would be that the elements of negligence are present. Gross negligence is not a different cause of action. Gross negligence is a matter of characterization, indeed submission, one might say. The pleading requirements are to plead the facts upon which you base your claim. And it may be useful to just test it in this way. If we hadn't explicitly said gross negligence in the pleadings, in the draft, would it have been sufficient for that to have been said in a covering letter? We intend to rely upon the existing allegations of negligence, and will be submitting in due course at trial that this constitutes gross negligence. And it comes...
Well, I'm sorry to press this, but there wasn't anything about negligence in the 14th of January draft which wasn't already in the pleading before Mr. Justice Foxton. And the whole premise of the preliminary issue was that gross negligence had not been pleaded and needed to be if it was to be run.
That was indeed the position as the parties had considered it at that moment in time. I'm not too sure how far the parties had addressed their minds to the concept of gross negligence at that particular juncture. All that was said in the Foxton judgment is it's not a cause of action. But the point arises from how one defines gross negligence, and that's a point which I deal with in my skeleton argument.
But does it matter, any of this? I mean, if you complied with the order of Mr. Justice Bryan by serving a document, whatever it said, we then move on to the question of whether you're entitled to permission to amend to plead whatever you applied to a plea for.
Yes.
And you now say you want to add a statement that says this is adds up to gross negligence. Well, maybe it does, maybe it doesn't. That'll be for the discussion on whether you're entitled to have permission to amend. But I just don't see that the discussion here on this appeal as to how many angels can stand on the point of a gross negligence needle really matters, does it?
I would agree. Let me be clear about this. The position throughout, my position was, we complied with the order.
Yep.
We now have an application to amend, which you have to deal with. It's not a question for relief from sanctions. I was trying to steer the deputy judge away from that as best I could.
You didn't get very far.
I didn't get very far.
Yeah.
And if you do apply the usual principles for applications to amend, think about it for just a moment. We have an existing case, allegations of breach, and I'll take you through those in a bit more detail so you can see how we get to gross negligence. I think that may be important. All that essentially is being added in terms of the gross negligence claim is the gross negligence epithet, the characterization of it.
Might that mean that the point that you've been debating with my Lord Justice Males could be significant if you weren't given any permission to amend at all?
Yes.
In the sense that on what you're saying to us, you could pursue the claim anyway on the existing pleadings.
Well, that was
alleging gross negligence.
That was indeed what came out of discussions with the deputy judge, because at one point the deputy judge said, "Well, isn't this a matter for the trial judge?" And I essentially agreed with that, but of course there could be some difficulties with that, and I would then had to take some instructions from my client so he could understand what we were discussing, because we started off the second case management conference with this dialogue, as often happens with counsel and the deputy judge. We were just trying to progress everything and deal with the issues and line up what are going to be the appropriate issues. And one of the points which did emerge was whether or not actually one needs to have permission to run gross negligence point. My position was that we have to put them on notice, and that was why I've given you the example of maybe a letter as opposed to a covering letter with draft pleading. But in fact, all that we did was, when we produced the second draft in terms of gross negligence, nothing was done in connection with wilful misconduct other than to tidy it up a bit, was to add the words which appear, I think, in paragraph 80, 81 of the draft, which say we rely upon the breaches of duty as being gross negligence. Now, the position of the deputy district judge was that we did need to plead gross negligence. We hadn't pleaded gross negligence. To plead gross in the first draft, and to plead gross negligence, we would need relief from sanctions. And in my submission, that was the wrong approach. And if one looks in terms of an application to amend, all that we've added in terms of gross negligence is this epithet. So no possible prejudice. And indeed, if one to compare the first draft with the second draft in terms of, well, what have you done which is different? Again, the only thing which we've done is to add the gross negligence epithet. We then go on to we then had further argument on willful misconduct, the allegations of abuse of process, and those raise different issues. Essentially, what I would say is that with regard to willful misconduct, the judge undertook almost like a summary judgment application on our existing pleadings. I know the authorities talk about it being it should be undertake a mini trial, but essentially what we ended up with is a sort of almost like a mini summary judgment application based upon the existing existing pleadings, and I would say she was wrong to do that as well.
Well, I don't understand that. I mean, she's entitled, isn't she, to do a mini summary judgment application on your permission to amend to plead 2 new causes of action. Gross negligence, if that's a new cause of action, but anyway, a new claim, and willful default or whatever it is.
Yes. One can well, I think one has to be a little bit careful, because this is where some of the authorities now suggest, the Khalastchi case in particular, is suggesting and being relied upon by my learned friend as the authority that for an application to amend, we now have to put forward evidence to support our position. Indeed, I think they go so far as to say we should have adduced some form of expert evidence on that application to amend. So what I do accept is that...
Well, do you accept what I put to you, which is to plead the 2 new claims? The court is entitled to look whether there is a real prospect of success.
Yes, I do accept that. Absolutely.
And that's what she did, and she said there wasn't.
Yes, and I will deal with how she dealt with it. Because what she didn't do is she didn't look at the amendments. She looked at the existing causes, the existing allegations.
Yeah, but it's got nothing to do with that. I mean, you'd already been told you couldn't claim the existing claims, but you were asking to make 2 effectively new claims that Mr. Justice Foxton had said you could make as a matter of law, in theory.
Yes.
And then she was deciding whether you could in practice.
Yes, and in my submission where she made the mistake is that she went too far in terms of her analysis. And again, I'll need to take you through the pleadings to explain that.
Well, just explain it in a nutshell. What did she go too far in doing?
What she did is she looked at one very small element of the claimant's pleaded case, which related to something called the Heartland Agreement. I need to explain this.
We have read the paper.
Yeah, I know. So you've understood. Yes. And the...
Sorry, you say that's a small element of the claimant's case, but it's the entirety of the case against the receivers.
No, it's not. That's what I'd say.
Right,
it's most definitely not. And that's why I would like to take you through the pleadings in some detail in a moment. Not in massive detail, but certainly to make good that point.
Right.
But it's an element of the... It's an issue within the case. The difficulty is that when one looks at it in terms of inconsistencies and the like, we would say there isn't an inconsistency. So the issue is would Mr. Samady have effectively been willing to enter into some sort of arrangement with a purchaser, which would have meant that the purchaser would have paid more money for the site. So to sell on effectively the benefit of the Heartland Agreement. What is pleaded is that the date on which he was willing to negotiate a sale was the same date as the property was actually sold, because of course at that point he realises the game is up, there's no prospect of refinancing. That of course is the situation which in fact occurred. That's what actually happened. In terms of looking at the loss which arose from the various breaches of duties, we say firstly there was obviously the much shortened marketing period. There was a failure to really understand the lease position, such that actually the Heartland Agreement, even if it had come to light from the receiver's perspective, it wouldn't have made any difference. And then the receivers never grappled with the real issue, which was actually the fact that they were saying to letting it be known to putative purchasers that the lease, the 2003 cafe lease, not the sublease, the 2003 lease, that was still in existence. Of course, if that was still in existence, then the Heartland Agreement is neither here nor there.
So sorry, that third point was they hadn't grappled with the real issue, which you say was letting it be known to purchasers that the head lease.
The head lease was.
And why would that have made a difference to a purchaser if they know that there's still a sublease?
Well, they wouldn't have known that. They would not necessarily have known about the sublease, but the purchasers were being put off by the existence of the, as far as they were concerned, the potential existence of this head lease, which was run for 35 years, no break clause, and that would have potentially impeded the development, because part of the development was to knock down this thing called a podium, and to do that you need to get vacant possession. And again, sorry, I'm sort of...
Sorry, I'll just proceed a moment longer. So there's no head lease, but there is a sublease.
There is a sublease.
Was that on shorter terms?
No, but I can't remember the precise terms of that, but the substance of the Heartland Agreement meant that it was within Mr Samady's power to effectively bring that to a close instantaneously.
But all that means is that the prospective purchaser, had they been fully informed, would have known that the person with control over this interest was a discontented shareholder, rather than anybody else who would have owned the sublease. Why would the receivers think that that made a difference?
The main is the purchaser's perspective.
Well, it isn't in a sense. The question is, can you infer from what the receivers didn't do that they were grossly negligent, or that there was willful misconduct on their part? Therefore, they have to ask themselves as receivers, if we tell the purchasers that the head lease is gone, but the sublease is now in the control of the discontented shareholders, will that encourage the purchasers to bid? Well, why should they think that?
Well, the reason for that is that they will know that we'll call them disgruntled shareholders, have the power to effectively terminate the sublease. They then have two routes, potentially, to terminate the sublease. One either through the tenant, the subtenant.
Well, is that right? Because if you've got an option over the sublease, how can the tenant on the tenant's own dispose of the sublease?
Oh, I see. Yes. Well, I think it comes to this, doesn't it? A putative purchaser would know that what they're dealing with is a developer who no longer has an interest in the site, who has the benefit of this option agreement, and is able to deal with that developer in circumstances where the developer no longer has an interest in the site.
But why is that any different from... I mean, they know that there's somebody who owns an interest in the sublease. Why does it make a difference who that person is?
Well, there may be a difference in terms of the status of the individual. So if you've had, for example, Heartland Residential Company, who are using this place as for their business use, their attitude towards surrendering their lease may be quite different to that of a somebody who's acquired one of these options. What it also reveals is that, in fact, actually, the Heartland Residential Company was not that concerned, because it had entered into the Heartland Agreement. And that is, if I might put it this way, rather clear evidence to the market that the Heartland Residential Company is not going to be a real obstacle, because essentially they've already signed away their rights to remain. So from a developer's perspective, you have this, called the podium, you have the various leases, all of which, apart from one, can be terminated. This cafe, the cafe sublease has already been terminated. And all that's left is a sublease, but what the market should have been aware of is that the sublessee had already entered into an agreement which effectively meant that they were not going to put up resistance. So that, in terms of a development of a property of this nature, means that you're not going to be stuck with a long period of delay while you're trying to negotiate the vacant possession of this one particular unit.
Where do you plead this? Where do you plead this? Can we look at the plea?
Well, that's what I've been endeavouring to do. So may I start there? So, shall we look at this? So, can I ask you to turn to the existing re-amended particulars of claim?
This is the final version.
No, I was going to take you to the pleadings as they currently stand. We could look at either because they're obviously in similar terms. Would you prefer to look at the draft, the second draft? Thank you.
Definitely, because then we can see the whole thing.
Yeah, of course. So the second draft is at tab 11. It starts at page 120. And I'll take this fairly quickly. Paragraph 1 deals with the position of Mr Samady. Essentially the director in control of the claimant company. Paragraph 5 and 6 on page 121 have a description of the development site and its purchase in October 2015. Paragraph 6 deals with a little bit more detail about the intended development site. And paragraph 7 is the material paragraph which deals with the podium, which is a building at the southwesterly part of the development site. And you'll see that the planning permission had been granted for this development. By way of background, the acquisition was funded by two facilities. The first was a senior facility agreement. You'll find that referred to in paragraph 8. And a mezzanine facility agreement, which is referred to in paragraph 11. In terms of neither of those are particularly important. There was security. That's mentioned in, as one would expect, security, paragraph 16, 17 in the form of a debenture and a mortgage.
Yep.
And one point to note in connection with the mortgage is that there was a security agent by the name of Citus. Paragraph 17. Paragraph 48. Sorry. Yes, paragraph 48 refers to the default. It was the claimant's case vis-à-vis the first defendant that default itself was a result of a breach of the senior facility agreement, but it doesn't make any difference for present purposes. And paragraph 55, you'll see that there is reference to this sale of the loan under the senior facility agreement to a company connected to Meadow Capital Management. Completion of that transaction occurred sometime later, which I think is the date which coincides with the ultimate completion of the sale of the property. Paragraph 57 is the appointment of the receivers by Citus, and that occurs on the 10th of August. And at the end, you'll see that the receivers had a deed of indemnity from an entity known as Meadow Real Estate Fund, an organisation connected with Meadow. Yep. Paragraph 70, page 145. I've asked, 61. I've just been asked if you could draw your attention to 61 while we're here.
Yes.
Paragraph 70. Deals with the ability to obtain vacant possession. Paragraph 71 deals with the the head lease and the sublease, or the Broadway Bar Cafe. Paragraph 72 deals with the Heartland Agreement. I just then draw your attention before leaving this to paragraph 83.
Well, just before you leave paragraph 72, the sentence in the middle of it, which begins at all material times once it became apparent to them,
Yes.
that has to be read in conjunction with your further information.
Yes, it does.
So that we understand it to mean from the 8th of December, when the sale of the development site was agreed.
Yes. Because this is the point where certainly I was in, it was not my pleading, but certainly I was in two minds as to what actually was being referred to here, because...
Well, however many minds you were in, Mr. Lundy, that's what your pleading says.
That's what the pleading says, yes. The curiosity about it is that it refers, so I'm looking at the wrong paragraph, was not achievable by reason of the events complained herein.
Sorry, what's...
So we're looking at the same sentence. This is the third sentence, I think it is, in paragraph 72. At all material times, and I will take you to the... I'm taking you to the request for further information which deals with this. At all material times, once it becomes apparent to them that the refinance and development in course or by reason of events complained herein, the events complained herein, and there's a request for further information which deals with this, is actually the appointment of the receivers. It relates back.
Yeah, but in the further information, where is that? Might it be an idea just to look at it while we're looking at
Can I come to that in a moment, because I'm going to deal with the Heartland Agreement in more detail in just a moment, and I will take you at that moment to all of those provisions.
I mean,
all those pleadings.
I'm very keen to see precisely what you did plead.
Well, I don't mind taking you to it now.
Supplemental bundle, tab 6, page 75.
Yes. Thank you very much. Yes. Page 75. Yes, I'll come. I'll come back to that in a moment. But it is paragraph 4.8.1. Please set out with precision the date on which it became apparent to them. original intention not achievable, the relevant date is 8th of December 2017. Then 4.8.2, essentially why? Well, because at that moment in time, it's been sold. So any hope of refinancing at that juncture was gone. So in terms of their final thought on the matter, that was when the property was sold, because at that point there was no potential for refinancing. So that's the position, if I could put it that way. And it was.
Is there a pleading anywhere that Mr Samady and Mr Ross were willing to negotiate before the 8th of December?
Well, the difference, as you may have seen from my skeleton argument, is that there is a general willingness to engage and assist, and then there's a willingness to negotiate. The gist of the claimant's case, and again I'll go back and show you this in a moment, is that if the market,
Sorry, if I just stop you, I'm not concerned so much with what's in the skeleton argument or what is the gist of the claimant's case, but where in the pleading do we find an allegation of willingness to negotiate before the 8th of December?
All right, that's why, if I go back now to where I was, I can deal with that, because it's important in my submission to take it in steps.
Well, you can take it in steps, but my lord is asking what seems to me a fairly pertinent question.
It is a pertinent question, and
is there a pleading about it?
Yes. Can I just go back to find? It's taking slightly out of order. Can I take you to the amended reply as a
Tab 14?
Tab 14, page 202.
Did you say?
202, yes.
Thank you.
Paragraph 30B deals with the Heartland Agreement and its materiality. And it also sets out the claimant's case as to what the prospective purchasers should have been informed of. 30B. Paragraph 30G.
So what are you getting out of that? I mean, I can see the second sentence. Samady and Ross acquired rights 2 months before the sale contract. The existence of such rights being highly material to any prospective purchaser, regardless of whatever might prove to be the precise timing and method of the eventual performance of the Heartland Agreement. That's not said to be a pleading of a willingness to negotiate.
I'm getting to that.
Okay.
I thought it'd be useful to take it step by step.
Okay,
so
no, that's fine.
You can see the material provisions at this moment. Paragraph 30G and 32. And if you want to look on to the relevant paragraph, it's paragraph 32. So there's the willingness to engage in this process at that moment in time.
Well, can we just be clear as to what moment?
Yes, and the reference to the emails are in paragraphs 69 and 70 of the defence are emails dated the 13th and 14th, sorry, the 14th and 15th of November.
We're in a position to negotiate arrangements.
And then paragraph 32.
Is that consistent with the further information?
Well, again, it's a question of what does the further information actually relate to. In my submission, it relates to the actual negotiations. And it also relates to the actual intention as at that time. What it doesn't in my submission deal with is, if I put it this way, the counterfactual. So this is an allegation of effectively professional negligence. And what we have here is a pleading which sets out what the claimant's position was in the circumstances which arose. My client's case is that there should have been a longer marketing period. There should have been better information provided to the market. And if that had happened, part of the overall matrix in terms of the value which could then have been derived from the site is the existence of the Heartland Agreement. How much value one gets from that is a matter, he says, for expert evidence. It has to be a matter for expert evidence. You look at what might you have achieved if you'd had a longer more proper marketing period, if the market was fully appraised of the position vis-a-vis the 2003 head lease. If there's expert evidence to the effect that actually the market value of the property was £92 million.
In a sense, this is one stage further down the line, isn't it? The prior question is, can you infer from the matters on which you rely that the receivers acted with gross negligence or by way of willful misconduct?
Yes.
If you can infer those things, then perhaps expert evidence is appropriate to find out whether there was any loss. But the prior question is, can we infer from these things that there's gross negligence or willful misconduct?
And I haven't got, because we've been jumping around to different bits, I'd intended to take you through the pleadings to say why, in my submission, there is gross negligence, or at least an arguable case for gross negligence here.
So just concentrating on the Heartland Agreement, I know you say that's not the totality of it. What is it that, on your pleading, the receivers have been told that they then failed to pass on, and from which one can infer that they acted with gross negligence or willful misconduct? So what had they been told about the Heartland Agreement that really it was obvious they should have passed on?
Well, it's slightly more complex than that, because the case as against the receivers is that the real problem was with their understanding of the head lease, in which case the existence of the Heartland Agreement is neither here nor there. It doesn't make any difference. No matter what they might have been told by Mr. Samady, it didn't make any difference. Mr. Samady would also say in his...
So what is the real problem then? The case against the receivers is the real problem is their understanding of the head lease.
Yes.
What is that?
Can I then take you back now to the, as I say, we're jumping around a bit, and I'd endeavoured to deal with that.
I'm sorry, you must answer my lord's question, but just while we're on paragraph 32, before we go somewhere else, paragraph 32 of the reply, you don't plead, do you, that the receivers were told what is said in the sentence beginning, they were eager and willing? I mean, that's certainly not what the emails say, at least as far as I can see. But you don't plead that the receivers were told that, whatever it means. I mean, I don't know what, on terms which would have been accommodating to any purchaser thereof, means. But whatever it means, you don't say the receivers were told that.
No, it's the emails, and there was also a conversation with a Mr. Gaze, which reflects the terms of the emails. That, again, I can take you to.
Yes.
To
Well, I mean, my lord's point there is that you don't say that the receivers were told what is pleaded in this paragraph.
No, well, in my submission, that comes out from the emails. That is, I think, the way in which it is currently pleaded.
Who's Mr. Gaze?
Mr. Gaze is an employee of Knight Frank, who were assisting with the marketing of essentially the estate agents who were dealing with the sale of the property. Mr. Gaze. Can I?
So just before leaving the
Yes.
point, paragraph 32 then goes on to say this was indicated in the email, pleaded, and the conversation.
Yes.
So, in terms of finding out what the receivers were told by way of email, it's just those emails.
It's just those emails and this. Yes.
And otherwise, it's a conversation with Mr. Gaze, which is then
Mentioned
pleaded.
below.
And that's at the end of paragraph 35, is it?
I was just looking for it.
So you don't plead anything, as it were, additional in the conversation, which we don't get from the emails.
No, yes. Whilst we're here, perhaps it'd be useful just to note what's said in paragraph 37. Yes, I'm going to.
Yeah, and what do you get from that?
Just that is part of the claimant's case, that essentially that what was happening, and the reason for the lack of communication was that there was an element of marginalisation. So that, in my submission, would fit in with the general thrust of his case vis-à-vis gross negligent willful misconduct, that they were trying to keep Mr Samady at arm's length.
But that can't be at all uncommon in similar situations, that there's
may
a
not-
breakdown in the relationship between a shareholder in the mortgagor and receivers. You can't infer gross negligence.
No, I'm not asking you to infer from that. I'm not asking you to infer from that, but that's part of the background to it. What I'm, in terms of gross negligence, I'm still trying to get back to the elements of that in a moment. But 37 is worth noting at this stage while we're here, and also paragraph 32A. Where it's the phrase, it became apparent once and for all.
I mean, just coming back a moment to paragraph 32, the point about what the receivers have been told about the Heartland Agreement, which you say they should have passed on, and that, and we can infer from the fact that they didn't, that there's evidence of gross misconduct, gross negligence or willful misconduct. It takes one back to paragraph 69 and 70 of the defence, where we see what the receivers were told, and there's no evidence or which it isn't suggested in the pleading that they were told anything different.
Yes, I think perhaps I should be clear about this. In terms of inferring gross negligence, this is not a central part of my client's case. It is part of it, but the real gist of it comes from the marketing and how the head lease was dealt with.
Okay.
And so this, in my submission, the whole issue about the Heartland Agreement, in effect, comes, foreshadowing my learned friend's submission, it becomes almost like a point of defence, which is like, well, even if we'd done everything correctly, you still wouldn't have actually agreed to sell the Heartland Agreement until such and such a date, by which time we'd already sold the property. To which the answer is well, if you marketed it properly and you'd actually engaged and actually understood, we would have been getting much better offers. And there was always this willingness. It's just that actually, on the facts which actually occurred, we never got to that stage.
I follow that. In terms of willful misconduct, the question is whether we can infer anything from what the receivers learned from the emails quoted in paragraph 69 and 70 of the defence.
And that would relate to certainly one part of the just be clear about this, that would relate to paragraph, one particular paragraph in the draft, the second draft. It won't necessarily relate to all of them. It would relate to the inferences which are being invited in the draft in paragraph 74, which is page 146. But that would be the very specific factual allegation which it would be relevant to. But in my submission, one can also look at the case more broadly and look at the other elements, which I'm going to take you to, which is the marketing and how one deals with the cafe lease, because those are the factors from which one might be able to infer, well, actually, there was something more to it than just mere negligence. And indeed, the onward sale to Meadows, or the Meadows entity, we don't know the connection on that. Those factors, again, also point to something more in my submission than mere negligence. Yeah. So can I just now take you to what's in the defence of the receivers to just deal with the marketing?
I mean, I thought we were going to be looking at the allegations that you make, the particulars of willful misconduct and gross negligence.
Yes, well, that's what I'm. So
why are we going to the defence before we see
the general allegation?
You've got to persuade us that the judge was wrong to say there was nothing in your claim of willful misconduct and gross negligence.
Yeah.
So shouldn't we look at that? That's why we went to the pleading in the first place. We
Can I
everywhere except to the.
Can I explain why? So the pleading, the general pleading, relates to the marketing, and that's paragraph 80, the breach of duty, paragraph.
What's the
81, subparagraph 1.
70.
General allegation, failed to market the development site adequately in all respects, in particular by marketing for approximately just 40 days. Now the reason for taking you to the defence, and indeed I would like to take you to the defence of Knight Frank, who were acting for receivers, is that at this stage, before we've had any disclosure, much of the information which we know of has to be derived from these other pleadings. And so the reason for me taking you to them is that this is the only place where one finds the particulars which give you a better insight as to how one can get to a case of gross negligence. So if I could ask you to turn to page 52.
I mean, you haven't even shown us the last two sentences of paragraph 74. The receivers willfully withheld this information from prospective buyers despite multiple requests to Knight Frank for the information to be made available as requested by potential buyers. Knight Frank and potential buyers viewed this as critical. They did so willfully to suppress the buyer interest and hence the value of the highest bid. I mean, that's the critical allegation, isn't it?
That's one of the critical allegations.
Okay.
And what I'd like to do is to take you to, and what I intend to do is show you where that comes from. Because it comes from the Knight Frank defence, and it comes from what is already in the receiver's defence, but principally the Knight Frank defence.
Okay.
So in terms of the...
Where's that?
Can I ask you to, well, what I'd like to deal with just first generally to set the scene vis-a-vis the marketing. The details which we have of the marketing at page 165, paragraph 52 of the receiver's defence. And the starting point is that the receivers were appointed on the 10th of August. Knight Frank are appointed on the 19th of October, and then on that day there is then an initial mail shot which is sent out. There's an email reminder which is then sent out, and then if one goes down to paragraph 52.8, we find that the property is advertised once only in the Estates Gazette, and it's advertised on the 28th of October. And these dates are all significant because, as we'll see in a moment from the Knight Frank defence, initial bids were expected or required by the 17th of November. So that's 28 days after the property first goes onto the market. The marketing exercise starts. In terms of, we don't know anything about, from this we can't tell, but we don't know, all that we know is that various details are sent out to Knight Frank's agents in their global network. We hear nothing about when the agents then pass that detail on. So 28 days from the initial mail shot, 21 days from the advertisement in the Estates Gazette, and that's assuming people read the Estates Gazette on the day it arrives, or the day it's published. In terms of the likely timescales, there's very little information. The only information which one can get is an indication from Knight Frank's retained letter, which is pleaded, which refers to them being retained for a period of 6 months. And the reference to that is paragraphs 17, 18, and 18.3, which is in Supplemental Bundle 1, tab 6, page 15 to 16. And we can find further detail of the bidding process at page 38, or supplementary bundle number 1, paragraph 34 of the Knight Frank defence. and in particular paragraph 34.1.3 and point 4, we have the conditions. You'll see that what was required is proof of funding as well. All purchasers assumed to inspect the site, satisfy themselves, etc. And reviewed and taken into account the documentation in the data room. And it's first round to be submitted by 12 noon, 17th of November. So substantial property, complex property, one would say, in terms of its development, and a bidding process which requires bids to be submitted within 28 days.
I mean, that's
Let me
dependent on expert evidence.
exactly dependent on expert evidence. The next step in the process is to look at what then happened in terms of the bidding. We can find out detail of that from the receiver's defence, paragraph 53, page 166 of the core bundle, tab 12. And we'll see that there are reference to 7 bids, and I should just add this is not admitted in the reply on behalf of the claimant. 7 bids received. We don't have any detail of 3 of them, but presumably they're not worth mentioning, which one we might say in itself is evidence of inadequate marketing. But the significant one is the bid at 53.1 from Trinity, which is for 92 million, completion on the 31st of December. Now, the significance of the 92 million is that very much corresponds with the pleaded figures, which I've already taken you to, 94 million from the Savills valuation report. And this is the bidder who would seem to have the best knowledge of the property on the information mentioned here, which is they'd undertaken due diligence on the property twice in the last 5 years. We obviously don't know the extent of that. Galliard Homes, there are then the 2 Reichman Sports Direct bids for lower amounts, depending on the completion date, and then 53.4 Galliard Homes, but the offer was said to be subject to conditions including vacant possession on Wizard Inn's unit. One turns over the page to paragraph 54. We go into the second round of the bidding process. This was to last just a week. And during that time, the Trinity bid was withdrawn, and there are some reasons which are pleaded as being given to Knight Frank. Paragraph 55. To which I should add that the claimant takes issue with that and says, in fact, that's not the reason, which certainly they were provided with. You'll see that paragraph 22, page 199. And the critical point here is actually just the second sentence. Both Angelo Gordon and Trinity complained to Mr Samady of inadequate time of being allowed in the bidding process. And whilst we're here, we would also just perhaps note paragraph 20, which also refers to other complaints which had been received about the marketing time. If we go back now to the receiver's defence, page 167, paragraph 56, we're left with the one bid, the Reichman bid. And then paragraph 58, we find out that Meadow Partners are going to send in a bid. This isn't a bid within the bidding process. This is completely outside the bidding process. And indeed, the entity making the bid was not named. And you'll see it was a proposal for an exchange within 5 days. Completion on or before 20th of January. However, this was later amended to 15 days and a long stock completion date of 31st March. Don't have the detail of when and why that was agreed. But the point to note is that certainly the initial contract was for a very short completion and a very quick deal, if I can put it that way, five working days. And so one might be thinking is that, well, we have a lender here who has been sitting in on the bidding process and knows that now we've got through the bidding process and the main bidder has withdrawn, we've got a clear run at this. And so we'll put in a bid at what we'd say is an artificially low price. We can get a little bit more about this bid from the Knight Frank defence. It doesn't come from receivers, it comes from, one has to go to Knight Frank. And you'll find that at page 40.
What's happening now depends on the bidding process having been conducted improperly, because the Meadow bid is higher than any of the bids under the bidding process, so the claim of wilful misconduct or gross negligence really depends on the earlier part of the process not having been done properly. Is that right?
No, I think it'd be continuation of the whole process. And one also has to look at how they were dealing with the head lease, because in my submission, we'll come to this in just a moment. What has happened in terms of the marketing process, you've got a very truncated marketing process, and virtually everybody within that marketing process is being misled about the head lease, such that they just don't...
Yes, that's why I say the earlier part of the process not being done properly.
That not being properly. And then you add on to that, you then end up having a bid from the lender. And one of the curiosities in this is that we plead, for example, it's a connected entity, and the receivers don't actually admit to that or provide any detail of that. Despite, as we'll see, being told specifically by Knight Frank that at this point in time they really needed to act with transparency. This is why I'm taking you to the Knight Frank defence.
Okay.
And you'll find that at page 40, paragraph 34.9. And Mr Gandhi is from Meadows. So, and the reference for that in the pleading is paragraph 14 of this pleading. One goes back and you'll see that Mr Gandhi is a Meadows representative. And you'll see that paragraph 34.9.3, likely to submit a bid, and Knight Frank saying next steps should be kept as transparent as possible. And then the bid is referred to 34.10.2. So we would say we have a situation where we've had the truncated market period. I'll come to the head lease problem in a moment. Everyone's pulled out, apart from one bid, the long completion date. Lenders are made aware of this and are able to then bid, if I can put it this way, from a very strong position, in a way that none of the other bidders have been allowed. And then, of course, we then have this extension of time, later variation, we don't know when, why, the circumstances, where you've got an extra 3 months for completion, a luxury which Mr Samady would say was not given to any of the other bidders. No further marketing, no attempt to deal with the issue relating to the cafe lease, which I'm now going to come to. And in terms of the curiosity about the close connection, the claimant pleads at paragraph 76 of the particulars of claim and at paragraph 78, subparagraph 4, these are the close connection. The receivers essentially avoid dealing with this. The relevant paragraphs in their defence, paragraph 81 and 83.4 on page 79.
Sorry, the paragraph numbers were...
Sorry, so the claimant's pleading about close connection is paragraph 76 and 78, subparagraph 4.
Yeah.
The response from receivers is paragraph 81 and 83.4. So here we have obviously Knight Frank saying everything must be as transparent as possible, and nothing, not even now, are receivers willing to admit or deny the close connection. Now, my lords, I'm now going to take you on to deal with the data room and the head lease, and the case as against receivers on that. So the starting point is obviously the paragraphs I've already taken you to, paragraphs 70 and 71 of the particulars of claim, whichever version you wish to refer to. There that refers to the head lease, the cafe lease and the cafe sublease. Of course, we don't know what receivers were actually thinking about this, but we get a little bit of an insight from their defence. So you remember that paragraph 70, 71, the importance of obtaining vacant possession, and in fact the cafe's the head lease had been surrendered many months ago in February 2017. Paragraph 62.1 on page 168 is the receiver's response. 62.1 is, you'll note, essentially a bare denial. And perhaps surprising. One is looking at the development of a property which involves the demolition of the podium and the construction of new apartments. Why is vacant possession not necessary? A bit further development. And then 62.2, further or in the alternative, obtaining vacant possession of the cafe would not have meant obtaining vacant possession of the podium, and it refers to a number of other long leases. So here's essentially receivers saying, well, it wouldn't have made any difference. And indeed, that may well be their thinking at the time. We don't know. The answer to that is found in the reply, and I can take you to this, paragraph 26, which is that each and every single one of these leases either had a break clause in them, and any business renewal, any application for renewal under the 1954 Act, would have been successfully defeated by section 30, subsection 1, little f, which is the provision dealing with development. And so one starts from, in my submission, the proposition that actually if this was actually what receivers thought at the time, that in itself is potentially quite a serious matter. They haven't taken steps to familiarise themselves with the leases and haven't properly understood the position, which may explain why they did not regard the cafe lease as being important.
Right. Serious to gross negligence or serious to willful misconduct?
Let's go to gross negligence at this stage.
And, I mean, were your hypothesis right, that might suggest that there wasn't willful misconduct.
No, but we can then we'll go on to one step further. One has to take it bit by bit, because this is the first step. We then look to see what happens when the problems begin to emerge. And essentially, just to foreshadow this, essentially receivers, we don't care, get it to market. Paragraph 62.3 is perhaps also worth noting. Page 169. In addition, there are other tenants in the development site with long leases. In order to facilitate the surrender of the leases may well have been required. Again, on this one, no detail provided whatsoever. And so the question then is again, if receivers aren't even able to identify it now in their pleadings, what proper inquiries had they undertaken at that time? Was this a case of which they may have willfully closed their eyes in terms of, this is where we get to the potentially inferring willful misconduct. But in any event, we'd say we're getting to gross negligence, if we're not already there. The reason one can say this really amounts to gross negligence is you see what's pleaded in paragraph 63.3 of the receiver's defence, where they admit that the cafe lease was closed at the land registry. Reference is made in the reply to a particular provision from the land registration rules, which indicates very clearly that the land registry has to be satisfied that there has been a termination of the lease before they close the leasehold title. Rule 176, the land registration rules, pleaded in the amended reply. So it's there, if I can put it this way, it's there to be found on the, if one made proper inquiries within, for example, using some lawyers. But it's actually worse than that, because the surrender was actually signed by Citus, the security agent, who appointed the receivers. And that you'll find the reference to that at paragraph 61 of the amended reply, page 213. Carrying on with the receiver's defence, 87 of the receiver's defence. Yes. To which the response, if it assists, essentially is that which you find at paragraph 59 of the amended reply at page 213.
I mean, is this the way you took the judge through the case?
No, we didn't. We moved on very, very quickly.
Well, moved on very, very quickly. I see no reference in her judgment to any of these pleadings at all.
The reason I'm going through it in much more detail is anticipating what's in the respondent's notice about causation and the like. And to be able to deal with that, one has to go through the basis of the case in much more detail. But no, I quite accept that the deputy judge wasn't taken through this in as much detail as I'm taking you through it now.
Was she even asked to read these pleadings?
Well, I can't say that I think that she would have been asked to read them as part of the. I don't. The question is, did I take her to them at that stage? The answer is no. A lot of the references which are made in the draft amended particulars claim, indeed the existing re-amended particulars claim, are to the Knight Frank defence. But what I'm doing is taking you to some of the other elements, just so that you can see that if one tries to put the Heartland Agreement in context, it isn't just, this case isn't just about the Heartland Agreement.
Yeah, but what I've wanted since we started all this to look at is the re-amended particulars of claim and what are said to be the elements of willful misconduct and gross negligence.
Yes. Well, gross negligence, just again to be entirely clear about this, gross negligence is the same allegations of negligence.
Yeah, what are they?
Well, I'm taking you through them. So the first one was the marketing. The second is in connection with how one treats the cafe lease, the head lease.
So the point there essentially is they knew or ought to have known that the cafe lease had been surrendered, but nevertheless it was included in the data room, and so
Yes.
purchasers would have
Yes.
seen it.
Yes. And in terms of what was happening, as far as we know it, behind closed doors, as between Knight Frank and the receivers,
And in terms of willful misconduct, just in a sentence?
is what we'll see is that these issues are raised.
I mean, you say what we see, but we're already at 12:05
I-
on one day appeal.
Yes.
Yeah. So what do you say the willful misconduct is that you've pleaded that the judge ought to have found had a real prospect of success?
Well, the judge thought, again, to take it in stages, the judge thought that the willful misconduct issues passed muster. She dismissed the application in connection with willful misconduct on the basis that she considered that we didn't have a reasonable prospect of success, or realistic prospect of success, on, if I can put it, the Heartland Agreement, which is why we've been discussing the Heartland Agreement in so much detail. So we passed muster. We passed muster on lateness. We passed muster on the basis that what was pleaded was adequate to raise a case of willful misconduct. But, she said, you don't get permission to amend because you don't have a realistic prospect of success dealing with the Heartland Agreement issue, which she described as the inconsistencies within the claimant's case. And what I'm endeavouring to do is to show you not just that that was the wrong approach, but actually if you look at it, it isn't a case where there is no realistic prospect of success in connection with the Heartland Agreement, but actually the case is more broader than that. And obviously if you're going to reconsider whether or not permission to amend should be granted, if we get to that stage, then obviously you would wish to be persuaded that in fact what is there could amount to gross negligence. So in a sense I'm trying to deal with it all in one go. So perhaps I'll just take this quite quickly in terms of the remaining paragraphs of the Knight Frank defence, because these are matters which are, some of which are pleaded by reference in the re-amended particulars of claim. Paragraphs 20, so we can start at page 18 of supplemental bundle number 1. Which in very broad terms deals with the discussions as between the claimant, Mr Samady, and Knight Frank. And paragraph 24.17, on page 24, we find just before the marketing of the properties meant to take place, 16th of October, there is a meeting between receivers and Frank Knight, dealing with outstanding information from the claimant. Also, our point here is that actually the information relating to the cafe lease is within their own possession anyway, or should have been. And the receivers instructed the marketing campaign would need to be launched regardless of whether more information is coming. So just started. And the same point is made in the next paragraph, 24.18. Launch tomorrow, come what may. And 24.20, there's reference to a conversation, I think it must be an email from the third defendant, one of the receivers, to Mr Samady, saying that Knight Frank had not provided an appraisal to the receivers, they'd not been provided with all the information they needed to properly appraise the property. So going into this marketing process, apparently, if this is correct, Knight Frank not been able to properly appraise the property. Then we go into what happens during the bidding process. Page 26, paragraph 25.2. Again, this is cross-referenced in the re-amended particulars of claim, something which is relied upon. You'll see that, in fact, we then have the putative purchasers querying how planning permission could be implemented with the cafe lease in place. Paragraph 25.6, and this is perhaps gives an illustration of the problems with the truncated marketing period. You still find that you putative purchasers continuing to inquire about the 2003 lease. This is just 11 days before the 14 days before the deadline for initial bids to be received. And then we have the third defendant, apparently, and we don't know, this is pleading the receiver's defence, indicated that he understood that there was a surrender premium informally agreed. They discovered that there was a head lease and undertook to speak to the claimant solicitors about this. And then they received 25.7, an email from the claimant's solicitors who had been dealing with the surrender, a proposed surrender. But there's nothing more, there's nothing to indicate further inquiries were then made of those solicitors to ask whether or not that actually had been completed. Citus wasn't approached, the land registry wasn't approached. What then happens is that there is something which is raised on the website marketing under frequently asked questions, FAQs, and you'll see that 25.9 is essentially how it was put. We're aware of a proposed surrender. So this gives to the putative purchasers an indication that this lease is still in existence. And so when one considers this in the context of the truncated marketing period and the come what may attitude towards the marketing of the property and the fact that there doesn't seem to have been any serious investigations in this, what receivers were quite happy to have is information put out to the market which was potentially misleading. No real explanation for that. Indeed, it's quite difficult to think of a good explanation for that. They then have the bids come in. There are queries from the putative purchasers. The bidding process is then closed. They must know at that stage that the market has been confused, at the very least. We then have the main bidder withdraw, apparently, or certainly on Mr Samady's case, from inadequate time to deal with this. And then you have the lender stepping in. And if I can put it this way, if you're one of these putative purchasers looking and trying to assess this property at a very quick period of time, if one looked at the frequently answered question, and the answer to the frequently answered question, one would go, well, gosh, if the receivers don't know, how are we meant to find out? My Lords, that then would, in the course of my plan submissions, we would have then dealt with the Heartland Agreement, but I've already dealt with that. And you see that the Heartland Agreement then sort of fits into this general, if I could put it, we have various problems which have arisen. The answers which are being provided by receivers suggest that negligence, at the very least.
Do you really say the Heartland Agreement is a red herring? Is this your case that?
No.
It's just part of a much more general picture of grossly negligent, if not willful, misconduct in marketing a property and allowing a lender to come in at the last minute without proper marketing having taken place, who obviously knows much more about it, and letting it go at an undervalue.
It fits in this way. If we get through all all the different steps, and one of the best ways.
Back to your grounds of appeal, which is sort of quite important.
Yes. Again, just to be clear, I'm anticipating in a lot of this, I'm anticipating the argument raised in the respondent's notice, which is essentially that no matter how we dealt, no matter what we say, we would lose on causation. To which my response is, the Heartland Agreement isn't really doesn't get them home on causation. Because on the pleadings, all that's being said is, well, this is what our actual state of mind was at the time in these circumstances, but we're always willing to deal with a prospective purchaser. If the procedure had been dealt with, marketing procedure had been dealt with better, with reasonable care, what would have happened is that the putative purchasers would have approached Mr Samady, and indeed there is, I can take you to this in a moment, there is suggestions that what they were going to do if queries were raised was that they were going to be referred on to Mr Samady, but that never happened. So what Mr Samady's case is that if they'd done what they said they were going to do and had done this properly, putative purchasers would have come to me, would have found out not only that, for example, the cafe lease had been surrendered and there was this sublease in place, but the sublease could be, in effect, not discounted because they had the ability to terminate that sublease very, very quickly and easily because that arrangement had been in place. So it's part of, if I can put it, it's part of the overall matrix, it's part of the complaint, but one has to put it in its proper context. And its context does not provide receivers with a complete defence to the claim. Now, in terms of the perhaps I should just draw your attention to it's paragraph 42A of the just a minute, I got a wrong a reference which is wrong. There is a reference which I need to provide you. I've unfortunately put the wrong one down in my notes, but it's essentially there is a conversation between Knight Frank and the receivers, and I will find it, whereby it is said that if there is further information which needs to be provided, that they will refer the matter to Mr Samady. So I'll find that. Unfortunately, the reference which I've got is not correct. Is not the right one. In terms of how the claimant put its case, there's one more document which I think I ought to take you to, which is the very pithy response of the claimant to request for further information from the receivers, which you'll find at page 67, 66, tab 5. Page 66, 67, the relevant responses are at 1, 2 and 3. It's a very short request, but it's a very pithy summary of the claimant's case in terms of the Heartland.
Why would you talk to CNM about the Heartland Agreement? It's not their agreement.
No. Well, that's I think the distinction which is being made. CNM, obviously acting by receivers. Mr Samady and Mr Ross are the people who entered into the Heartland Agreement. So the idea would be to refer to them, effectively, as third parties.
So when it says, I may be getting this wrong, the receivers should have directed Knight Frank to refer to CNM any inquiries in response 1
Yeah,
2.
yes, I think that
it should be to Mr.
Yes.
Samady and Mr. Ross.
Yes, that would be consistent with certainly what has been pleaded elsewhere.
Yeah.
No, that's all I'm going to do in terms of taking you to the pleadings, so you can see how we would say we can rely upon the existing allegations of breach as constituting gross negligence, and we would say that from what I've taken you to, there is certainly enough in terms of the pleadings, what's currently pleaded, from which the court can start to draw inferences from as to willful misconduct, because at the moment what you have is things which cry out for a proper explanation, and in the absence of a proper explanation, the court can draw adverse inferences as to what the state of mind of the receivers were, and in particular when you have a scenario where receivers are selling to the lender at the end of this, what might be thought of as a rather truncated and artificial marketing exercise. Now, in terms of the appeal, the allegation or the position with regard to gross negligence was that at the outset of the hearing with Miss Dyer, so I could take you to the transcript, but maybe in light of time, what I'll do is I'll deal specifically with what's in the judgment and in the reasons which were given. We worked to a position where I made an application for relief from sanctions and for permission to amend in terms of gross negligence. So relief from sanctions and permission to amend in connection with gross negligence. By that stage, the judge had already come to the conclusion that I needed relief from sanctions. Probably the best place to look at the reasons are actually in the reasons which he gave for refusing permission to appeal, which you'll find in tab 7. there are the 4 paragraphs. It's page 43, my lord, tab 7 of core bundle. It's an email.
Got it.
So what had happened is this point had effectively come a little bit out of the blue, because what had happened is the claimants were saying, actually, you're saying, well, you're struck out. That was what was in their skeleton argument. The point was then raised by the deputy judge that she didn't think the case had been struck out, but I still needed relief from sanctions. There was then some toing and froing while I was trying to tease from her the reasons for that, so I could then respond to that, and we get to the point where I make the application. But the starting point, if I can put it this way, is, in my submission, really quite simple. There was no breach of the Bryan order. The Bryan order required us to provide a draft. In giving judgment, the deputy judge referred to the spirit and intent of the order. There's a bit of a difficulty with that. There are 2 difficulties. First is that there was no judgment given. It was a consent order. So there's difficult to find the spirit and intent. But in my submission, if one looks at the spirit and intent, yes, it was certainly to encourage the claimant to get a move on. There's no question about that. But there's nothing in the order which said anything about that once you've served the draft, that you're then stuck with it. And in my submission, that would have been a sensible approach for both the claimant and the receivers to adopt at that stage. So in terms of the spirit and intent, yes, claimant gets a move on, but no, we're not shutting this out. This is going to be dealt with under the usual principles relating to applications to amend. The order itself doesn't even refer to an application to amend. The second point which comes out of the judge's reasoning is that we were putting forward an entirely different case. Now, the basis for that seems to be that we put forward a case on willful misconduct in the first draft, but not gross negligence. Point out in my skeleton argument, in fact, actually the words breach of duty and willful misconduct, or willful misconduct, I think, were included in the draft. But what, in my submission, the judge got wrong there is to consider draft 1 in terms of what was actually in it, and consider draft 2, what was in that. And in terms of gross negligence, the only difference is the inclusion of the gross negligence epithet. So in terms of making a comparison between the initial allegations of willful misconduct and the gross negligence epithet, in my submission, that's an erroneous comparison to make. And then one is looking at it, all right, if it's a question of reasons, a reason for this, the reason was advanced, which is, well, actually, we realized that what we produced wasn't sufficient to put them on notice, that gross negligence was being a case which was being run. And therefore, to remedy that, here we are, we're putting it in just to make it absolutely clear. Has there been any prejudice in the intervening time between the delivery of the draft in 14th of January and the making of the application on the 9th of May, delivery of the further draft on the 6th of May? No, nothing's changed. And in terms of, and the final place is perhaps a very obvious one, if there had been a breach of the Bryant order, we would have been struck out, because that was what the sanction was. And the authorities on that are fairly clear in my submission. Macron, Shipping 2007, I can take you to these if necessary, but I don't think there's a real dispute between the parties on this. You're either struck out or you're not. So you either comply or you don't comply, and if you didn't comply, you're struck out. We complied.
Yeah, well, you made that point.
Yeah.
Let's carry on.
My Lord, I don't think there's much more which I can say on that. In terms of the authorities, there's a case which I can refer you to, which is the Libyan Investment Authority case, but obviously each case very much depends on its facts, and there's nothing in that case which establishes any point of principle. My learned friend I know relies upon another case, QFS, which deals with further information, taken over by a later case, dealing with further information. In my submission, again, it's off point. We either comply or we didn't. If we didn't, then we were automatically struck out.
Yeah,
And indeed, I think
we got that.
I don't think there's anything I need to now say further with regard to the gross negligence point.
So just so I'm clear, you say no need for relief from sanction because you complied. Therefore, when the judge approached the matter by reference to relief from sanction, she was approaching it on a wrong basis.
Yes.
Therefore, we have to ask ourselves afresh, do we, whether or not to grant permission
Yes.
to amend? And you say, well, when it's only a matter of the addition of the vituperative epithet, that of itself can't be a reason for denying permission to amend. So I suppose the only answer would be Mr. Simpson's answer, well, there's nothing in it anyway.
Yes. Yes, that is it. In terms of the gross negligence case. Obviously, I accept that if you're going to consider it afresh, you obviously have to consider whether what I've taken you to is of itself sufficient to raise a case of gross negligence. Can it be characterised as serious? Now that, of course, is very difficult for me to make any further submissions on, and I don't intend to do so. Gross negligence equates to, if I can put it as, serious negligence. And so that's why I've taken you through the pleadings so that you can see how one gets to that point. I didn't need to do it with the deputy judge because we went straight into relief from sanctions. And I lost straight off on relief from sanctions, and that was the end of the matter. The willful misconduct allegations are, in a sense, much simpler to deal with. In this sense, we don't rely upon anything new. That was not what was intended. Although, having said that, there is one point which I need to draw to your attention, which I couldn't find on the existing pleadings, which does seem to be a new factual point. And it's only right that I draw it to your attention. And it's a paragraph 77. It's a very small point. Which is at the end of paragraph 77, it's about the original bids requiring completion pre-Christmas. And I've not seen that pleaded anywhere else. But in the grand scheme of things, not a particularly significant point. But obviously Mr. Samady believes that that's what the position was. That, of course, in itself doesn't establish any willful misconduct. Just further background.
When you make a specific plea of willful misconduct in relation to the Heartland Agreement in paragraph 74,
Yes.
and that, I think, is the point which Mr. Simpson criticises in his skeleton argument. But do you also say that you make a much more general plea of willful misconduct in 76, saying that the whole process from the very beginning was all designed to get a pre-selected buyer to purchase at the lowest possible price?
Yes.
Which is maybe that's what the judge had in mind, saying speculative and weak. It's certainly a pretty serious,
It's a serious accusation.
surprising allegation.
Yes.
Would
So
you say
that
rendered the entire process a sham?
Yes. Well, that's as I say, that's what Mr. Samady. Because remember, it's Mr. Samady who settled this. This is what he felt was appropriate. I'm not making any application in connection to amend this in any other way. it must stand or fall on.
But I mean, as I understand it, you have taken us through all the extraneous material, which you didn't take the judge through, in order to show precisely that. I mean, this is really a fraud case. I mean, it's an allegation of a sham is a fraud, right? And I know it's not sham in the traditional sense. I mean, either you say that or you don't. And you say this was all a put-up job, and it was always intended that the lenders would come in and ride to the rescue in a few days. They knew what was going on, and they scooped the pool, and it was at a gross undervalue.
Yes.
I mean, I think one should stop beating around the bush sometimes.
No, I'm not. No, there's absolutely.
I mean,
let me
you
be
say
clear about
that, and the judge said, and I mean, do you also say that it's not good enough for the judge to say that this was weak, or what was the word she used?
It's weak and speculative.
Speculative.
Weak and speculative.
You say speculative is something different. She had to decide whether it was pleadable and had some prospect of success, a real rather than fanciful prospect of success, and this weak case does on all the facts you've shown us. That's your case. I mean, it's actually quite simple.
It's actually quite simple. Certainly with regard to the willful misconduct. I mean, this is why one has to, in my submission.
I'm not sure there's any difference. I mean, if it's a sham, if the whole thing is a sham, then gross negligence adds nothing to it. It's
well, it may be that on the evidence at the end of a trial, one might reach the threshold of gross negligence.
I understand,
but not obviously the sham element. And so, what one is concerned is to be able to run both of the points.
Yeah, but if you get the point I'm making is if you get to sham, then gross negligence, as you say, is a staging post.
It's a staging post, but we may still need the staging post.
And I mean, normally when we hear appeals, somebody says, look at paragraph 13 of the judgment. She got it wrong there. You just say, what do you say?
Well, in terms of gross negligence, because I haven't.
We understand what you say about sanctions and gross negligence, but in terms of willful misconduct, what do you say?
Can I take you to because that was my next step.
Good.
Was to take you to the judgment.
I mean, it's not very long, and it's not.
No, it's not very long at all.
Which is the paragraph where you get your screwdriver in and say she was wrong?
Yes, sir. It's a tab 5.
Yeah, we've got the check. We just need the paragraph now.
Paragraph. We do fine until we get to paragraph 26. Up until that point, we passed muster, dealt with lateness. We're okay up to there.
Mm-hmm.
I'm also entitled to look at internal incoherencies and inconsistencies in the claimant's own case. Pointed to a number of inconsistencies, in particular the contingent nature, even on the claimant's own case, of a willingness and ability to sell the sublease. Again, that's based upon the pleading which relates to their actual intention in this truncated marketing period. What it doesn't do in my submission is it doesn't actually deal with what would have happened, if I can put it, the counterfactual, if the marketing process had been undertaken properly and matters had been referred to Mr Samady. So it's taken it a step too far.
Does your criticism come to this? And I'm trying to understand from your submissions as a whole, rather than what you've just said, that even if the judge is right in what she says in 26 and 27, that is to say that the pleading relating to the Hartland Agreement is hopeless. Nevertheless, your case is in fact rather more than that, as you've been at pains to show us, and she doesn't look at the whole pleading.
Yes, that's the thrust of my skeleton argument. There are, as I say, there are 4 different approaches. This is just one part of it, and that, in my submission, if we're looking for the laser analysis as to what's wrong with it. That is to treat the Heartland Agreement, the issues relating to the Heartland Agreement, as being determinative entirely of everything else.
Does she actually go so far as to say that your case on the Heartland Agreement is hopeless? She says, refers to a serious doubt.
Even if the Heartland Agreement is established, the alleged to be made, and the information value is given, it made it significant to the marketing value. Well, the problem with that isn't that would be a matter for expert evidence, which is what we'd already pleaded, which is that we'd been asked as to whether or not we could actually put a figure on it, and the answer to that is, well, not really.
I mean, you say she didn't really answer the right question. It's all very well saying it's speculative and weak. If you're rejecting a claim for permission to amend on the basis that the claim is unsustainable, you have to show that it has only a fanciful or no real prospect of success, and she didn't say that.
Well, I think she may go on. To be fair to her, I think what she did say is at paragraph 30.
Even if it cannot be said the case is bound to fail.
Decidedly weak.
Decidedly lacks conviction.
Yes.
Is that the
and
test?
36, speculative and weak.
I mean, is that the test?
Well, no, say it's not.
I mean, your grounds of appeal sort of dart around at paragraph 4, but you do eventually
get there.
Eventually get there at paragraph 4.4 and say she was wrong. I think that's
well, there we are. That
what you have to say.
Yes. Well, that.
Okay. Well, look, I think we've got it.
Yeah, I think yes.
It's a funny way of doing it, if I may say so.
Well, I'd had a route map which I'd intended to follow, and we took a slightly more circuitous route, and we got there in the end.
Well, I mean, what personally I found difficult is that I wish I'd been told that I had to get my head right into the pleadings to read every aspect of the pleadings in order to see not only because normally in these cases, Mr. Lundy, I'll be perfectly frank with you, we're looking at the particulars of claim, and we say, does this create a sustainable case, or is the case fatally flawed in some way? And if it is, we won't give permission, and if it doesn't, it's simple. You say, no, you've got to go much further in this case. You've got to look at the whole thing, you've got to see what the other parties have said, and then you see that there is a really sustainable, or at least not fanciful case, that there was willful misconduct by these receivers and gross negligence, at least.
Yes.
Put like that, I think I get it.
Yes, and I do apologise because, in fact, one thing I did notice, and unfortunately much too late for me to do anything about it, is I didn't provide you with a pre-reading list.
No, we're not going to criticise.
No, but for that, I do need to apologise for that, because that would have obviously assisted.
It would have helped. Is that it?
Yes.
Right, we're going to rise for a couple of minutes.
Clockwise. Just to inform you, the live streaming will be running on. They're only popped out for a few minutes.
I've had did a case Jeffrey Boycott in front of Mr. Justice Watson. No, it wasn't. It was to but it was actually professional negligence. And it was all to do with limitations. Actually, he gave the judgment against us. Very interesting. We got permission to get an insurance because it was professional negligence on both sides. And well, no, I was actually convinced we were home and dry because we just got a tribunal because of other cases. And it would have been sort of in the landmark case in Hoyster. Yes, there's something I can't remember the ins and outs, but it's all to do with limitation, and it was to do with knowledge of events and that sort of thing. is quite, yeah. I think he was quite enjoyable. You know, I don't actually didn't mind. But that's why you earn your money.
Yeah.
To be able to do that, though, that's where basically 4 days, 5 days. Just trying to rebut in effect. Yes.
Sorry, I didn't appreciate it.
It's not always like that.
All rise.
Yes, Mr. Simpson.
My Lords, I'd like to start by going to the particulars of claim and the amendments to the particulars of claim. And the first material proposed amendment is at paragraph 74, which my Lord the Master of the Rolls saw as central. In our submission, it is central to these wilful misconduct amendments. Lords, that's at C11 146.
70. Yeah.
The red bit is obviously the key bit, and it starts by saying that the receivers willfully withheld this information from prospective buyers. Now, before we go further, the information that is said to have been withheld is set out in the previous sentence. And we read the whole of that sentence. The purchase of the shares in Heartland by Mr Samady and Mr Ross, ultimately achieved by means of an SPV, would have been highly material to any prospective purchaser of the development site, if, as should have been the case, the receivers had informed such prospective purchasers of 1, that fact, and 2, that Mr Samady and Mr Ross were anxious to conclude arrangements in connection with the cafe bar on terms favourable to a person wishing to develop the development site. Now, pausing there parenthetically, Mr Lundy acknowledged that that second fact does not appear in the emails, which are the only emails on which the claimant relies. And that is sufficient to dispose of that point, because the receivers could not have informed the purchasers of something which they themselves had not been informed about. Now, in essence, CNM has 3 fundamental problems at this point, all based on the pleadings. First, it's clear from the emails that CNM relies upon that Mr Samady did not give the receivers either piece of critical information. My Lords, we've
Sorry,
been...
Samady did not
give the receivers
receiver.
either piece of critical information. And your Lordships will remember that the emails are set out in full at paragraph 69 of the defence,
Yeah.
And neither of the relevant emails do not mention the Heartland Agreement. They do not mention Mr. Ross. They do not even mention Mr. Samady. They say we have entered into an agreement. And so that's the first piece of information. It's going to.
Are you understating that a little if we look at paragraphs?
Overstating it, my lord.
Or understating the effect of the emails?
Yes, my lord.
Or overstating the extent to which they don't say things?
Sorry.
Paragraph 69 of the defence, page 174.
Yes.
So it said, I would like to inform you that we have agreed and signed terms for the vacant possession of the public. Please inform potential buyers that vacant possession would be available.
Yes.
So, how far did that not convey what is indicated in paragraph 74 of the particulars of claim?
So, my lord, going back to the two pieces of information, the first information is that fact, and one looks back at what that fact is. That fact is the purchase of the shares in Heartland by Mr. Samady and Mr. Ross. There is a mention in the abstract that we have signed terms for vacant possession, but that is a significant gloss on what had actually occurred by way of the Heartland Agreement. There's no mention of Mr. Ross, and there's no mention of the Heartland Agreement.
I'm not quite sure I follow what the material difference is. So Mr. Samady says, we've agreed and signed terms for vacant possession.
Yes.
You say, well, that's different from saying that Mr. Samady and Mr. Ross have entered into an agreement giving them an option to blah, 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 blah.
Yes.
But the thrust of it is the same, isn't it?
My lord, ultimately there was a mechanism whereby Mr. Samady and Mr. Ross could have acquired the cafe sublease. That is correct. And the Heartland Agreement I'll refer to by way of a shorthand as doing that going forward. So to that extent, there is mention of an agreement that has effect that we, unspecified, have the means to acquire that or have acquired it. I don't say that the difference there is material, but what they don't, what Mr. Samady doesn't mention, and when he is later asked does not send to them, is the Heartland Agreement. They are never sent as common ground. The Heartland Agreement, despite it being requested in the email which your lordships will see further down the page at 70. Now there, one of the receivers says, given the receivership, I'm not sure how you've purported to agree and sign terms for vacant possession without our input or agreement. You can understand the receivers being surprised. And please would you immediately provide us with a copy of any agreement you say you've signed and evidence of when this was done, as we may have to advise parties this was done without our knowledge. And it's common ground that the Mr. Samady did not provide at any stage a copy of that agreement. Reply 37 admits that he did not, and mentions, my lord, the point my Lord Justice Newey picked up on, fractious relationships between receivers and shareholders.
Yeah.
So that's the first piece of critical information, that it is not given or is given in allusive terms which don't mention a third party, Mr. Ross.
Well, you were telling us that CNM had three fundamental problems.
Yes.
A minute ago. That's the first.
I will return to that.
Okay.
Second, it's common ground that Mr. Samady himself, we've dealt with this now, my lord, did not provide the receivers or mention it to the, this is the second point, or mention it to the prospective purchasers that he met. He met around this time, my lords, two prospective purchasers, and again, it's common ground that he did not provide them with the Heartland Agreement or mention it to them. So we say rhetorically, how can it be wilful misconduct for us not to pass this stuff on when Mr. Samady didn't think it was, when he was himself meeting purchasers? And third, the third problem is that, as we've seen in argument, Mr. Samady and Mr. Ross were only willing to negotiate a sale of the sublease, prepared to negotiate a sale after exchange. I'll return to the distinction between being willing to sell and prepared to negotiate in a moment. But they were only willing to negotiate a sale after exchange, but that would be when it would be too late to affect the price.
Yeah.
So, my lords, I was going to expand, but I don't think I need to, on not having given the receivers either piece of critical information. My exchanges with my Lord Justice Newey deal with the first piece of critical information as to how much the Heartland Agreement was referred to. And it's acknowledged that it doesn't refer to the second piece of critical information, the emails don't refer to the second critical piece of information, that Mr Samady and Mr Ross were anxious to conclude arrangements with the cafe, in connection with the cafe bar on terms favourable to a person wishing to develop the development side. My lords.
Now, all of that goes to the point made about what you should have done regarding the Heartland Agreement.
Yes.
And might be a reason for not giving permission to include the language at the end of the language you read at the end of paragraph 74.
Yes.
But it doesn't address the wider aspects of the case which is sought to be made against you, that the whole process was grossly negligent or even a sham from start to finish. The shortened period, not dealing with the cafe head lease and so forth.
Yes, my lord, and I take the points that have been put in argument this morning, and I will return to them after the short adjournment. Many of them are new, but I'm able to deal with them. The way it's put, for instance, in relation to the surrender of the heart of the case being the surrender of the original lease.
Well, I think the heart of the case is actually rather different from that. I mean, as we're now told, the heart of the case that you've got to deal with is that the marketing process was fatally flawed and can only have been designed to allow a lender to come in at the last minute and scoop the pool at an undervalue.
Yes.
Now, look, we're not naive in this court. We have seen mortgagees sales before, and realistically, this can happen. Now, the question is whether sufficient material is pleaded here to raise a case that is neither fanciful, that is not fanciful, but is arguable, that it did.
Yes.
And I mean, I do believe, and I know that Mr. Lundy didn't like at all the red herring idea, but it does seem to me that the Heartland, he did at least say that the Heartland Agreement point is simply part of a much larger edifice in his case. And somehow the judge seems to have thought it was the only thing. Now, I think that the case now you're having to meet in this court is a bit different from the one you had to meet below.
Yes, my lord, and I'm not saying I'm incapable of meeting it. But if one talks about the edifice of a case in terms of a country house, then the central wing and several parts of the wings on either side depend on the Heartland Agreement. For instance, if one looks at paragraph 80, where the breaches are pleaded, then it is almost exclusively, so far as particularised, about the Heartland Agreement. And so you find from 83 onwards, although 80 Roman 3 mentions the surrender of the cafe sublease, the nub of 84 refers to the Heartland Agreement, and 80.5 also refers to the Heartland Agreement. And if one looks at the willful misconduct amendments, they are based on the Heartland Agreement. So it goes further than this, my lord, that if one is going to go so far as to willful misconduct and fraud, that the heart of the willful misconduct case, which is the heart of that case, does in fact depend critically on the Heartland Agreement. And no other particularisation is given in relation to why it is said that this was a collusive and dishonest process. So we have, in willful misconduct terms, The only particularisation relates to Heartland, and I say that if I can demolish that, then I've demolished the willful misconduct.
And I thought they said that it's not just a business of being collusive. It's the problem is that the process lasts 21 days. The bid is closed. Somebody comes in as a lender with information to a very complex transaction, and no time is given to anybody else. And the deal is closed straight away.
Well, in fact, in the paragraphs before the paragraphs that my friend took you to in the Knight Frank pleading, you will see that other offers came in after the closure and before Meadow bid. So it's not, the fundamental premise of that is it was a fix after the close of the process. And Knight Frank's pleading, on which he relies, gives details of other bids.
Okay, well, let's come back to this at 2 o'clock. Thank you.
All right.